Yeah, let's go ahead and call roll.
Commissioner Adero.
Here.
Commissioner Kasher.
Here.
Commissioner Hatch.
Here.
Commissioner Hayward.
Here.
Chair Remke.
Here. Okay, good afternoon, everyone. Before we get officially started with items on the agenda, we're gonna have a brief presentation. As you know, we have been striving in recent years to really improve our use of technology to increase transparency. In addition to some of our larger projects like the e-filing for Form 700 or the case management system, we've also just tried to have a complete overhaul of our website, improve access to information and pushing out data that we do have to collect. So I'm excited today to share a new online disclosure system that's going to make it easier to search and view behested payments. Now, as you all know, behested payments, that's when an elected official solicits a request from one individual or organization to give money to another individual or organization, and the payment is for legislative, governmental, or charitable purposes. But it's important to remember that unlike contributions or gifts, behested payments have no limit on how much is solicited or given. This new tool provides easy to understand and see visualization on who is asking for money from for their favorite charities and other causes. It also is going to allow for a word search on who is giving the money, how much they're giving, and where the money's going. An informed public is vital to maintain government accountability. This is another tool to help the public track the flow of money in politics. So I'm excited to share this with you, and I'm going to turn it over to Jay and Larry, who have been working on this.
Thank you, Madam Chair. Commissioners, good afternoon. As the chair mentioned, we're very excited to have this new tool, which will, I believe, give us a better sense of perspective and context just by looking at things before. If anyone had noticed our behested payment reports, they were basically an Excel spreadsheet. So we had the data, but it was very hard to extrapolate that data. So I'm here with Larry Crabtree, our Chief of IT. So first of all, thank you to Larry and his team for putting this together. We'll just make this short and brief. We'll start at the beginning, which is the best place to start. On our homepage, you'll see a transparency portal right at the top, and that will include the behested payments. So when you go there, first of all, the explanation, but the first thing, as opposed to what we had before, like I said, which was the Excel spreadsheets, this is a very, very bright and easy way to determine how much money is there, how much is being requested, and by whom. You have the statewide officials, the Senate, the Assembly, and the PUC, which are the ones that we are in charge of tracking and regulating. So, Larry, if we go to the, let's take the high number there from 2015, looks like about $22.5 million. And that is from the Assembly. So it gets broken down by each Assembly member. And let's click on Mr. Bonta there, since that one seems to be a little bit higher. And then it gets back into the details, but there is a running total for each one at the top. So you can see that he asked for about $3.5 million. You get the amount, you get the date, the payor and the payee, and what it's there for. So if we scroll through some of those, you'll see some of the groups that he asked money from, Dental Association. So now let's, I see AT&T there. Let's go to back here. You can, right above there, you click there, and now you can go to the search for who paid or who is receiving. So in the payer name, we would put AT&T. And then the year, let's go to 2015. And now you can search by group or company instead of having to search through that on an Excel spreadsheet where you'd have to literally look at every single page. Now it just pops up automatically.
So that's showing, right. If you're closer on your own computer, you can see that that's showing all payments made by AT&T.
To all the various groups. And one of the more popular items at the legislature are the caucuses. There are numerous caucuses. So if you want to see who is giving money to caucuses, you could put caucus under payee. Let's go to 2015 again. And now you'll see all the money going to the various caucuses, the Latino caucus, the Asian Pacific Islander caucus. I think I've read in there the Jewish caucus, Irish caucus, every caucus under the sun.
That's all from
And
2015. Right
That's
there.
all from 2015.
Wow.
So I think this is going to be an extremely helpful tool for the public and the folks that I deal with in the media who are asking for some of these numbers and keeping track. So again, I want to keep this brief. If you have any questions, we can answer those after the commission meeting. But again, thank Larry and his staff for this. And Chair, back to you.
Thank you. And yes, thank you, Larry, and everyone on your team. Any questions from the commissioners?
I don't have a question. I just want to say thank you. It's amazing. It's the amount of information that's there, I think, is great, and it looks very nice too. So I think the public it's just very user friendly. So
Right.
I think that's great. Thank you.
Okay, so
Hi, this is-
we will start.
Hi, this is
Oh.
Commissioner Casher. I also wanted to just thank staff. I have it up on my computer right now, and I'm clicking through. Very user friendly, lots of really good information, and the search function seems to work really well. Just type the last name, and it populated everyone who had that last name. So nice work, and I think I think everybody who uses this is going to really appreciate the ease with which they could access this information.
Thank you, Commissioner Casher. I agree, and I encourage everyone to go to it and play around with it. It's kind of fun to see the different searches, payers, recipients, stated causes. All right, now I will start with public comment. Is there any public comment for an item that's not on the agenda today? For public comments regarding items listed, we will call for those at the time they're discussed. Anything not on the agenda? Okay, seeing none, we will move to item 2, which is approval of the March 2017 committee meeting minutes. Any comments or questions or corrections from the commissioners on the minutes? Okay, is there a motion?
Oops, I'll move approval.
A second?
Second.
Okay.
Commissioner Adero,
I think I have to abstain. I was not here. I have no clue. I did not watch the YouTube, so.
Just if you want to clarify, but it's not crucial.
Well, we did a little research. When we had the new commissioners, because then we didn't know if enough could vote on the minutes. But right, we found in Robert's Rules of Orders, you don't have to be there to approve the minutes. It's just kind of you don't have to have been at the meeting.
You're approving the process.
Yeah, it's approving the process, but it's just a technicality. So, and we have plenty of people here this time.
It's fine, then I change my vote. Then I vote yes.
Commissioner Casher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so next is the enforcement matters, and we have items 3 through 39, which are currently on the consent calendar. And I'll start by asking if any of the commissioners would like to take an item off consent. Commissioner Odero,
Yes, I have a few.
okay?
3, 4, 5, 7, 8, 9, 10, and 36.
Any other commissioners?
No.
Well, to clarify, I had a couple too, but she covered them, so I don't need to reiterate.
Right. Okay, so then,
And then, excuse me, I have one as well. Galena West, we're pulling item 26. We didn't receive all of the documentation that we needed. So item 26 is being removed from vote.
okay, so no item 26. So as to the remaining items on consent, do the commissioners have any questions or comments about those items remaining on consent? Okay, hearing none. I will, is there any public comment for the items remaining on consent? Okay, hearing none. Is there a motion?
I move approval of the items remaining on consent, which would exclude 3, 4, 5, 7, 8, 9, 10, and 36, and 26.
Is there a
Second.
second?
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward, Chair Remke.
Yes.
This motion passes.
Okay, so now we will take each item pulled from consent one at a time, and we'll start with item 3. Do you want to go ahead and start, Commissioner Odero?
Okay, thank you. So this is brought in from last month's meeting, which I was unable to attend. I apologize. But I have to say that when I read the agenda last month, even though I wasn't able to attend, I was a little bit surprised about this item being on the calendar. I'm really honestly at a loss as to why we're pursuing count 2. Which is the conflict of interest issue. As I understand the intent, if you will, of the law, it's to protect the public from having a public official use the power of his public office, right, to have personal benefits, to obtain some kind of financial gain or any other type of gain. And so I'm honestly lost. And I saw that there were a couple of comments. I don't know the extent of the discussion. As I said, I was unable to watch the YouTube video, but I really am just very curious why we are going after an individual who, and we're trying to penalize somebody who voted against his personal interest in favor of the public. Why are we going after something like that?
Well, I had just one comment on this, maybe before we start, on the standard that's in section 87103, which is the main conflict statute. And it,
Can I interrupt?
sure.
Just to clarify, I do own some AT&T stock, so if I need to leave the room, please tell me.
Oh, that's right. We kind of looked at that question, and a decision on this stipulation would not present a conflict.
Because AT&T is not a party to
Right.
this proceeding.
They're not a party to the proceedings.
I had the same issue because we represent AT&T, but as I read this, I don't see that.
It would never
Yeah,
have an
correct.
effect on the a material financial effect. So what the standard is, it doesn't. It is just whether it would affect the person's economic interest. 87103. If they have a financial interest in a decision, if it's reasonably foreseeable that the decision is going to have a material financial effect on their economic interest. In this case, the council member / mayor's economic interest was in AT&T. He has AT&T stock, and AT&T was directly before the agency, so directly involved in the decision. And in that case, it's presumed to be material, and it doesn't. The act doesn't go to whether the person is going to get financial benefit. It's whether the decision will have an effect on their economic interest.
I.e. the shareholding,
The company,
the shares.
Well, not the shares. If it's indirectly involved, if this decision is going to affect like all telecoms statutes or companies, and it's indirectly involved, then it goes to whether it's going to change the price of the stock. But if they are the applicant or you're contracting with them, then they're directly involved in the decision, and it's deemed materials. It's presumed to be material, the effect on them. Yes. So it's
I
strict
think
standard.
The reg says it is
It
material.
is material.
It's not
That
even
it said it was
presumed.
presumed.
That
I
was,
think that's what's written here.
This one is material. There's two sentences in there, and the second one is material under this section.
Yeah.
Is it deemed material in all cases where there's stock holding involved?
In this case, since AT&T is before him, it is material.
Yeah.
It's not a presumption or anything. It just is.
Deemed, that means.
Yes,
Yeah,
deemed.
okay.
So, and as Hyla Wagner was saying, so Hyla Wagner was talking, Commissioner Kasher, and this is Galena West. And so the thing that the act is great about is that it doesn't make us look into the future. It makes us look at the time of the decision and only at that time. Because otherwise, for conflicts cases, you would have to look years down the road to see if it ended up benefiting or becoming a detriment or affecting it all. And so the good thing about the way that the conflicts rules are written, it's to prevent you from participating at all, good or bad. And so the rule is so black and white that if your interest is before you, you can't participate, you're not allowed. So even though it appears that he voted against AT&T's interest, we don't know what happened. We don't know what he said at the meeting. We don't know, because he also didn't leave the room, which he needed to. And we don't know if this decision ended up benefiting them or not benefiting them. We also have cases where when the person votes, they think it will benefit them and it ends up not benefiting their economic interest. Still a conflict and still causing them a violation. Because once it is your economic interest, the rule has to be strictly enforced that you just don't participate. You don't vote and you leave the room, in order for it to be a very clear-cut rule for public officials. And public officials also like it to be a clear-cut rule without black and white. In fact, every time we do a revision of the conflict rules, that's what we hear from city attorneys and county councils. They want it to be black and white because they want to be able to give advice. They want to be able to say on the day of the commission meeting, vote, don't vote. AT&T is not a party. AT&T is not part of the stipulation. You can vote. So they want the rules to be black and white enough that they can be applied so that public officials can vote and participate.
and I'm sorry, go ahead. I was just going to say, because I think the issue is, as the statute is written, it's beyond the vote. It's making or participating in a decision. And again, as Ms. West said, we don't know what was done or said leading up to the vote. And we don't know what that vote really meant. And I think it's not just, is the individual ultimately going to financially benefit? It's the appearance as well. Do we know how much he owned in AT&T stock?
His SCI said 10,000 and one to 100,000.
So 10,000 to 100,000?
Correct.
That was the amended after the fact?
That was, yes. And that was the other problem with this case, is that there was no disclosure of his AT&T stock before the vote. So even though we can presume by some of the facts that could possibly he is voting against his interest, but we don't know the whole story. And for us to investigate to find out the whole story would take years. So unfortunately, these are a snapshot in time. And so we apply the rules and we try to apply them equally and then take into mitigation that it doesn't appear to have benefited AT&T.
Having just filled out my first 700, it occurred to me that he may have been in a situation where his earlier report, he honestly didn't include it because his holding wasn't worth more than $2,000 at the time. Did you guys check to see if that was the case or whether he just,
I don't remember exactly when he obtained the stock, but it didn't seem that he raised that as any question of it didn't come up to, because it wasn't the smallest box to check, the under 10,000. So since it was the next box, I don't believe he even brought that up.
But he could have had, like, say, $1,800 worth of stock, and then whether it appreciated or whether he just added to his position in between the two reports. I don't know.
Mhm.
That's why I was curious. Once it reaches 10,000, it seems you have a heightened awareness that the party before me, I have a $10,000 interest in. I mean, I don't know. I guess to me, it is so black and white, and he wasn't a new official at this time, correct?
No, he'd been in office quite a while. But
And I feel like, as we know here, having received so many requests for advice from city attorneys, for city council members, this is pretty 101 conflicts information that is shared routinely and regularly. So I almost think, if anything, it's perhaps more egregious than we're looking at it. So, I have a different issue.
On the
But
other side of that, now that you raise it, to fill out my Form 700, I had to disclose holdings in 6 different brokerage accounts, 5 of which I manage. The 6th one has been managed independently at a full discretion registered investment advisor for like the last 30 years. And I rarely, if ever, look at the positions on those. And I was shocked and amazed to find I was an AT&T shareholder by virtue of that account. If you'd asked me the day before, I would have said, no, I don't know any AT&T stock. So,
But that's why we have the obligation, and that you, like you said, so diligently went through that process. And I know it's taking you time to do it because you had all of that information. And so that's the purpose behind it. I mean, the whole purpose behind disclosure is to force the individual to say, what do I own? What's going to be impacted by this job? I mean, as we know, a lot of people in positions divest interest if they have a concern that there will be too many conflicts.
I had several security holdings that were like 1,900 and something, so now I have to worry that next time so that's why I thought, well, maybe he was caught in that situation.
So further to this most recent part of the conversation, I don't have a problem with the failure to disclose. I think that count, I think it's correctly brought, and I think it's correctly penalized. But the issue that I have is that we are, as specifically as to count 2, what do we gain? What message are we sending as a commission, and what do we gain from pursuing this man who voted against his personal interests? I don't see it. Bring us a case that has somebody who voted in favor of his personal interest. I'm all over that. But to pursue somebody who voted in favor of the public and against his personal interests, and you're saying, well, we don't know that, and it's in the future, or whatever. But there's this presumption now, right? I mean, there's a presumption that this materially affected him. So, presumably in his favor, right? I mean, I can't imagine that this law was written to say there's a presumption against somebody who votes against his interests. I just can't imagine that that's the purpose of this law.
But you're saying his interest. It's about AT&T and the effect of the decision on them. So when you ask what
indirectly, because he held an interest,
right? But all you're looking at is the effect on AT&T, because it's directly involved. And so I think, in answer to your question, the message that we're sending is, if you have an economic interest and it is before you, don't vote. It's clear cut, and it gives everybody the same rules to play by, because you don't want a case where they tried to vote to benefit themselves and it didn't work out right. I mean, there are cases like that. You think that putting this in or passing this zoning thing is going to help the value of your property, and it doesn't. So by attributing another step into the conflict rules, it's causing public officials to not know. And this way, it's a clear-cut rule, and they can all follow it. And I think that is the benefit, and that is the message, is that you're saying it could benefit AT&T, it could not benefit AT&T. He should have left the room.
Is that statutory, by the way, or is that in our rules?
Which part? The leave the room?
The deemed to be financially interested when it comes to securities.
Well, it's the statute that says if there's an effect on your economic interest.
On your economic interest? I thought it was on AT&T's economic interest.
Well, the person,
Yeah.
well, AT&T is the council member's economic interest. So it's the effect on AT&T.
That's what I just.
Yeah.
I guess, no, it's still the effect on AT&T, because it's not the effect on you, it's the
Right.
effect on your economic interests.
Right.
I guess and maybe you can correct me if I'm wrong, Commissioner O'Darrow, but you said, why are you bringing this case in? it's pretty clear that our obligation is to enforce the law as written, and this is the law. We could disagree with the law.
No, I don't disagree with what you're saying. Of course, we agree that our job is to enforce the law as it's written. My question is, as a commission, why are we pursuing this case? Why aren't we putting our efforts into pursuing a case where somebody actually benefited? I don't see it. I'm not convinced. I think it's more on that. I'm not debating the law. I understand my role. I'm just not sure that this is how the commission should be.
But so once
spending
it's brought to our attention, though, under that, I'm just really trying to understand how we would handle it. So it's brought to our attention, it's a non-filer, we just investigate, discover that, in fact, he did vote on a party with a financial interest that appeared before him. Are you suggesting that enforcement not pursue that case? Because again, they don't have that discretion not to pursue a known violation.
We certainly have been exercising our discretion to not include counts of things that have been done wrong, right? We do have discretion, right?
I would say this is a pretty serious violation, so I would not put that into the combining counts kind of discussion, or should, instead of 5, should we look at 3 violations of the same type of misconduct? And I guess the other problem that I'm having a concern, or I am concerned about, is when someone votes on an interest that appears before them, that financial interest, and it's also just the bias. Can I be unbiased regardless of my vote?
I think this is a perfect example of somebody being unbiased.
But we don't know that. I think there's
Well,
been a
but-
lot of assumptions of how this turned out. Let's say this individual also owned Comcast. So by denying this appeal, they also know then Comcast, which they own $100,000 in stock, is going to get that modification to the poll by the Planning Commission.
Mhm.
Yeah, but
I mean, we just don't
there's no
know.
recourse there. I mean, if he owns Comcast,
You'd have to
he,
disclose.
yeah, he'd have to disclose it. And by the way, Comcast wasn't before the city council, so there would have been no recourse for that circumstance anyway.
Right. If I can follow up, I think what the chair is trying to say is that we don't know. We don't know if this somehow benefited one of his other economic interests in some way, which is what the act allows for and doesn't make us do. So one of the declarations and findings for the act is that you, as a public official, you have to you do your duties in a free, impartial, no bias way. So you can't be biased by any of your economic interests before, for or against a decision. And the courts and the case law have said that that includes any perception of bias. And so when you're talking about public harm, public officials voting on their economic interests gives the impression of bias. And that's what we're trying to avoid by having a clear-cut rule. Don't vote on your economic interests.
But you just added a standard here, which was if he had some other economic interest. That's not what we're looking at,
Well, I'm
right? We're
saying-
looking at
right.
AT&T. That's what we're looking
We
at. here.
are.
That's all
And
we
I'm
know
just saying
about.
we don't, but some of the assumptions that we're making are this definitely didn't benefit AT&T. This definitely didn't benefit the public official. And we're making these statements based on a snapshot of knowledge and not knowledge of everything else that could be. So yes,
Agreed,
that
yeah.
argument is on the could be's, but that's why the law is written the way it is, because it's written the way it is so that you don't need to know the could be's and the should have beens and the maybes and the perceptions that are beyond it. And that's what is great about the law, is that it just gives you the yes, the no, don't vote if you have an economic interest.
And I never got a clear answer of my question. Is this statutorily derived? Or is this from a regulation that interpreted the statute that got us to this deemed financial interest in there? No.
It's a statute. It's the statute.
The statute itself, is this like, was a part of the original Prop 9, or is this something?
Yes, the standard is in the original statute. It's in the 2 conflict statutes.
Okay.
I guess my last comment, and then I'll. Oh, you want to go ahead? Go ahead.
I would
first.
love to, thank you.
Sure.
Since I was the cog in the wheel that brought this up last month, let me share with you the the way I've at least come, I think, to think about this matter, because I think it's a little more complicated than maybe at first blush, to me anyway, because I kept tripping over the notion of how does the decision in the city of Belmont regarding AT&T's apparently, see, you can find the minutes to the Belmont City Council meeting, and you can find out what happened. And I read them, and apparently AT&T did some things, and the Belmont City Council was like, should you have done those things? And then I wanted to do more things. It was just kind of, messy city government kind of thing. And but the thing that I kept catching on was, okay, there's a deemed material effect because the entity is before the city council, but what you're really, I think, trying to capture is, which isn't captured, I think, very well in the reg, is the benefit to the guy who's got the power to make it happen or not. And that's going to be a change in share price. And even if you favored what AT&T wanted, I don't see how the poll in the city of Belmont is going to change AT&T share price as compared with all the other things that happen in the world that the market considers on any given day when the market trades shares in a publicly traded company, which is a long way of explaining that. And I had a sidebar the other day with our lovely general counsel, who I think refreshed my memory that at some time in the history of our regs, there was a recognition that a small shareholder exemption might apply in some situations, that the market in a publicly traded company is so big that the chance that this little thing is going to actually redound to the shareholders' benefit is really not going to happen. And so that's, I guess, the place where I'm troubled with this right now is I think that there's still an appropriate role to understand that the small shareholder of a big company, even that reaches a $10,000 threshold, is quite a different kind of economic interest than someone who holds a $10,000 interest in a company that's worth $30,000 and is contracting with the city, where you own a third of the company. Whatever amount of shares he has, he's not close to a third of AT&T. So, so I don't know. I guess I feel like the non-reporting of the economic interest is the real bad thing that was done here, and I don't have any problem with the penalty that we set for that. I guess because of my ambivalent feeling toward the effectiveness of the regs here, because of what I've just explained, I'd like to see the penalty for the voting when he had a conflict take a hit. And I think that would be my way of sort of doing rough justice between what I know the rules say and what I think the rules are trying to actually do, because I see some daylight between those two.
Commissioner Kasher, anything from you on this?
I'll just offer a couple of just thoughts on it. One is that and I do a lot of work advising public agencies, and I echo the sentiment described that I do feel like public officials in the regulated community, they do like to have bright line rules. And oftentimes the way in which this manifests itself practically is that you get a call to the city attorney's office or maybe the general counsel, and it's the day before a meeting, or maybe it's a week before, and when the agenda is posted, and they're forced to make a determination as to whether or not they can vote on something in relatively a short amount of time. And so to try to unravel and unwind, who may benefit, what the benefit may be of the ultimate outcome, not knowing, a lot of facts that can determine that particular issue, it becomes very, very challenging to advise clients and then for the public official themselves to actually make a decision as to whether or not to participate. I've also seen these kind of cell tower type questions come before planning commissions, and they, those can have a pretty significant impact on companies. If you are the only cell tower in town and you have pretty predominant coverage in a particular area that other cell companies don't, and they have bad service, that has a pretty significant effect on, the carrier or the provider that most people are going to want to use. But I think at the end of the day, it really comes down to, having a bright line rule, which I think most people really do appreciate. And then I do think that there is this issue there of perception. And, you know, if you do have a financial interest, there is a perception that you may have bias, and you kind of take all of that out of the equation if you just don't vote. And I guess the last point is, you know, oftentimes there's 5 members on these boards, or maybe even 7, and a recusal by that one member oftentimes won't impact the ultimate decision. So sometimes it's, from a practical standpoint, it's really an insignificant act for them to just recuse or abstain from voting, and it sometimes doesn't even have an impact on the ultimate outcome. But that's all I had.
Commissioner Odero?
So I just have a couple of brief responses. It seems like we're not willing to make the assumption that all was okay, but we are very interested in making the assumption that all might not have been okay. And I don't think that's fair. So we're either going to make some assumptions or we're not. That's number one. And again, I think I've already said this, but I think it bears repeating, at least to me. And that is, I understand the law is the law. I understand the law is very black and white on this. My concern is not with the law. I think, well, maybe I do have a concern with the law, but this is not the venue for that. I understand that. I'm fully aware of it. I just don't think that the commission should be pursuing this. And I think we have the discretion, and I think we should not. I do think that the penalty on the statement of on the failure to disclose a financial interest is warranted.
Chair.
Commissioner Hatch?
I'm still a new kid here, and I've been asked a lot of questions about various little things. And I'm just trying to synthesize it all. And what I find is that, you know, we get a summary of the issue, and then we get this stipulation of agreement. And even what's said in it is tailored in the form of a negotiation between the parties. And so sometimes what we see here doesn't tell us everything about the case. I mean, there may be, we negotiated to say only have 1 count instead of 3 on something, and maybe we've negotiated to recharacterize how some of the things are represented and so on. So there's a lot, it seems like a lot of discretion at that level before it ever gets to us. And I think what I'm feeling here from you is that we're in kind of a straitjacket. It's kind of like the cement is drying and we're not supposed to mess with it. We either say yes or no. And I don't feel real good about that, because I'm not particularly wedded with this one, but there's others I've seen that kind of bothered me, that I couldn't, you know, have some impact on it other than to say yes or no. And I would like to know to what degree we can tinker with this procedurally without picking on the particulars of this measure. As these come before us, do we have an option other than yes and no? And I know I was admonished last month that when we say no, it doesn't really help the person that's accused, because it just puts off the agony, but it's pretty much baked. That's not their words, but that's my synthesis.
Well, there are negotiated settlements, so there isn't, so what the commission is doing is the settlements have been agreed to between the enforcement division and the respondent. The respondent usually in 50% of the cases represented by counsel. So in the streamlined settlements and the mainstream settlements, the fine is agreed to. The enforcement division, the respondent has paid the cashier's check. They've paid the money. So there's not, it's like a contract. So there isn't the ability for the commission to
But is
change
this
them at that
contract
point.
binding until we vote on it?
It's approved when you vote on it, but if the commission doesn't approve it, it needs to go back to the parties. It's not like a default, because there the commission can
Right, yeah,
change
this
the
is
fine
this is an agreement, but it's
Right.
not binding until we ratify it,
until it's
correct?
approved. That's
Well,
correct.
Right. So the simple answer is, because they are stipulated agreements between the parties, our vote is limited to an up or down. And the down, the rejection of the stipulation does mean that the case goes back to the parties to attempt to renegotiate a settlement, addressing any express concerns that have been raised by the commissioners, which could be a little bit tricky if we all have different opinions about different issues. But anyhow, so it's a yes or no. If it's a rejection, hopefully we can give some direction or express our concerns so that the parties could try to reach another negotiated settlement, because if they can't, then it would go to an administrative hearing. And that just kind of brings me to what I was going to say a few minutes ago. And I think it is important because I've heard the word fair and, is this fair? And maybe these aren't the types of cases we should be going after. But I start from the premise that the respondent has agreed to the findings of fact and conclusions of law, has acknowledged the violation, and has found the penalty to be acceptable to resolve the matter. Not that we can't say it's too low, it's too high. I don't, I get everything. I'm not saying anything anyone said is inappropriate. I just feel that I almost feel like we're stepping in the shoes of the respondent's counsel at some point and trying to get this individual or any individual a better deal when they have reviewed the facts and the proceedings in their light, and this is acceptable to them. And again, as far as our authority and jurisdiction, we're under the Administrative Procedures Act, and it sets out the issues on resolving cases by stipulation. And I just have it in front of me, and it says the settlement may be on, I quote, any terms the parties determine are appropriate. Okay, so again, we can reject it. But then it also does point out that, approval of stipulations, and from the agency point of view, we really need to look to it to see whether or not it's contrary to statute or regulation. Again, that's the language under the authority in which we're acting. And reading a lot about settlements over the years, normally the recommendation and the instruction to the agency's adjudicators, it's not, would I have agreed to a different settlement? No, it's the settlement before us. Is it consistent with the law and the regulations and the fairness based on treatment to other parties? So that's my concern of kind of this getting too close to renegotiating settlements that have already been heavily negotiated. That's the different point of view I have.
Okay.
Commissioner O'Darrow?
Thank you. Okay. There's a lot to pull apart there, so bear with me as I try to do it methodically. We're starting from the premise of fairness. So we are the Fair Political Practices Commission. We are all about fairness. So I think that we have the ability to make statements about fairness. That's number one. The parties have agreed. I have negotiated multiple settlements in my life as an attorney. And I know from my personal experience, which I am allowed to bring to this, that many times it is just not worth the money to continue to negotiate. Here we're talking about, a $3,000 or $2,000, whatever it is. It takes very little attorney time to get to that point. So I can see where, in order to have this be done, somebody would throw in the towel and agree to a number. Okay, so the parties have agreed. I still think that as a commissioner, we also have the bigger picture, as a commission, I should say. We have the bigger picture beyond just the two parties. I look at our role, and correct me if I'm wrong, anyone in this dais, but that we are also representing the interests of the public to make sure that we have a fair system. And I think that gives us the ability, again, to talk about fairness. And then the idea of we're not allowed to go, our goal is to not go contrary to statute or regulation. Okay, but the regulation says 0 to 5,000. So the answer can also be 0. So those are my responses to, I still think count 1, I'm good with it.
Okay, thank you. Any further comments from the commissioners on item 3?
Yes.
Commissioner Hatch?
I just, I'm a little alarmed that we're in a situation designed to be that way, I guess, where we really don't have options at our disposal, we're supposed to either rubber stamp it or vote no. If it's no, then it just gets flipped back around and then comes back like a nightmare and just comes back up again, as this one has. We need to be able to have a process where if we, whatever our reasons are, don't agree with this, we should have a process for you to be able to take it back from us and do something with it. And I know, like in some of these others, I thought that the fines were too low. Some I thought maybe were too high, but there's often things behind it that might, rationalize that. But then I find out that these stipulations don't really tell you all the facts. They tell you the facts as worked out. So just enough to make it okay. So I can't really tell if the proposed agreement is in conformance with the statute and regulations and so on, because there's not enough information here. And so I just kind of find it offensive that we can't open this egg up a little bit and give you direction and go back.
We did in a prior commission meeting. I think we said we wouldn't approve it as is, but somebody moved, and I can't remember, maybe it was Commissioner Kasher, I can't remember, moved for a completely different stipulation. And in other words, it was kind of no with the instruction of go back and do this. So I think that we do have the ability to do something like that. And correct me if I'm wrong procedurally, but at the very least, I saw it happen once in my few months.
I believe
here.
that was a default. So we came to a settlement and we were instructed on what to settle at instead of the default.
But
because
we-
the person wanted to participate at that point.
But we do have the authority to reject it and with instructions. So it's not on like that. Then it's just up to the parties whether or not they're going to agree to what we instruct. So
I can't imagine that if we go back to him and say, would you like to stipulate it lower? He would say,
Yeah.
no,
I'm
absolutely
sure he'll
not.
say no, thank you. I've already written my check. No, I would just make one comment. The hardest part about this job is that you're heads of an agency. You have 80 people that do this for a living, that take it very seriously and dedicate our lives to it. Basically the whole reason that we're here is because of the mission. So I understand that although it's difficult to look at a stipulation and know that there may be things that have been negotiated out, but you also have to understand the ethical and professional staff that is here that presents you with regulations and statutory violations as instructed from the commission and as interpreted by the legal division and following the law. So although that is a difficult leap of faith and you just met me and you don't know my staff and you don't know how terrific they are and dedicated, and you don't know that they have 50 to 60 cases assigned to them and they work their tails off every single day, and that every case that you decide to reject, it goes back on someone's plate, which I totally understand. In the past, another thing that the commission has done when 3 agree is approve a stipulation and then say next time that this violation comes before us, we expect a higher fine. We expect a lower fine. That happened last year on lobbying reports. So when the commission is in consensus, when there's 3 that agree, then direction to the staff is greatly appreciated. We don't want to bring things that you don't feel comfortable approving. We don't want to bring things that get rejected and then have to be reworked. We do want the commission to work and we want it to function. We get over 1,800 complaints a year for a staff of 30. So we definitely want to hear what the direction of the commission is for violations and to make sure that there's agreement that the next time we present something that it will pass. So it's not I know that we all represent the people, which is what we're all trying to do. And so just know that that's what the enforcement staff wants to do. So when we present something to you, it's never to hide something. It's never to pull wool over your eyes. We actually put more in the exhibits than we ever have. In the past 2 years, we've added more facts, more comparable cases, because we add comparable cases so that you can feel comfortable that this is what has been done before, because without consistency, there is no fairness.
If I could, Madam
Or
Chair.
Hatch?
I didn't mean to give the impression of staff that I didn't have any faith in them. I want you to know that I came here believing that we have good, competent, and conscientious staff, and that they probably work a lot more hours than they're paid to do. My point is nobody, I mean nobody, does everything perfect every time. And there's a lot of stuff to sift through and a lot of judgments to be made, and it can't always be perfect. There has to be some procedurally built in, if it's not now, way that we can substitute our judgment to some degree. And I really don't have, any vested interest in this, in this particular issue, but I feel strongly that, we ought to get off on the right foot here. If we should feel, compelled to just, vote on these things, then you don't need me. It's just that simple.
May I?
Commissioner Odero?
So I too want to echo that, and please don't at any point think that we have less than 100% or 110% faith in you or your staff. That is not the issue, so let's just take it off the table. By the same token, we hope that you have the same faith in us as having the same dedication as the staff. But with both of those off the table, the idea of voting against what I believe in with the knowledge that I can then say, but in the future change this, is just not appealing to me. I would rather say, starting today and with this case, let's change it.
Any other comments from the commissioners? Okay, any public comment on item number 3? Okay, seeing or hearing none, is there a motion on item 3?
I move that we accept, and I don't know if I'm using the right terminology, but you'll get what I mean, that we accept and approve the penalty for count 2, that we reject the penalty for count 3, and that enforcement just simply settle this case with count 1 and drop count 2.
I second.
So just a little clarification, that just means, yeah, it just it's a vote, and it's rejected, and then it goes back, and then they bring it back with just your motion would be to bring it back with just the reporting SEI count, would be how it has to be done.
Okay.
They can't,
Okay.
I can't separate them and approve one and not the other.
That whatever it takes
Yeah,
to
to accomplish that.
So you're just, I think you said 2 and 3, so just so I get it clear, are you
1
saying?
and 2.
Okay,
Right? There's only 2.
Right.
So I apologize if I said 3. So reject.
So your motion is to reject the stipulation,
Yeah.
number 1, and most
and-
importantly,
yeah,
and
give instruction.
to not bring back count 2.
Correct. Thank you for everybody's help in getting that motion on the table.
Is there a second?
Yes.
There's a second. Go ahead.
Commissioner Adero,
Yes.
Commissioner Kasher,
No.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
No.
This motion passes.
Okay, so we'll move on to item 4. And Commissioner Odero, did you want to start? You pulled that.
Yes, I need to gather my bearings on this case now. This was a case where we had, failure to comply with the advertisement disclosures. So we had 2 banners that said that just were missing paid for by. 5 banners that had no disclosure statement at all, and then 300-yard signs that the disclosure was there, but too small. So the comparator, which was Southern California Tax Association or something like that, had, I don't know how many yard signs where there was no disclosure at all, and that was $2,500 penalty. And I guess the extra $1,000 penalty in this case, the additional, is because of the fact that the disclosures were there but too small. Is that, am I
Galena West,
understanding this correctly?
The extra violation was the banners. So the comparable case had only yard signs. And so then the banners didn't have the proper disclosure. They didn't have a committee name. They only had the website address, and some had no disclosure at all, which made it more egregious than the comparable case.
Do you have a comparable case that talks about banners having no disclosure?
I may.
That would be very helpful, because I feel like we're not comparing apples and apples.
Well, I think the problem is a lot of them have different things. So there's YouTube cases, there's banners, there's yard signs, there's giant signs, there's billboards. So since they're all under the same section, they all get lumped together. So I think there is another banner case, but it was significantly different, and that the banners, I think, were only an aggravation. It wasn't charged. So this was the closest comparable case.
Okay.
Any other questions or comments from commissioners on item 4? Any public comment on item 4?
Hi, Ashley Titus from Bell McAndrews and Hilltack. I'm an attorney that practices before the commission regularly. However, this is not my case. I don't know this respondent. I have no connection to this case whatsoever. But this is the third or fourth sign enforcement case since last summer. And I've had a problem with them since day one. And that is because the regulation talks about yard signs and it talks about billboards, but it doesn't define what the maximum size is of a sign before it breaches being a yard sign, which only requires a disclaimer if printed in quantities of more than 200, versus a billboard, which a single billboard requires a disclaimer. And so I am not aware of a statute, a regulation, an advice letter, other than an informal email that is not publicly available, that tells the public when something is so large that it's no longer a yard sign, where a quantity of 3 banners or 5 banners even requires a disclaimer, versus falls under the subdivision for yard signs, where a disclaimer is only required if more than 200 are printed. And so I have a huge concern that these gray areas in the law are being clarified through enforcement. These settlements are being given precedental value. And as Commissioner Adaro discussed, as attorneys, we know the give and take in negotiating a settlement. We're often looking at the dollar amount. We don't necessarily accept the legal theory that is put forth in the stipulation. And so I have a concern that when there's a lack of clarity in the law, as there is here, that the response of the commission isn't to provide that clarity first and then prospectively have enforcement matters when people don't comply. It's instead to commence enforcement cases and sort of define through enforcement what is and isn't a yard sign and what isn't a billboard.
I'm just curious, you mentioned an informal email, and have you, as an attorney from Bell McAndrews, requested formal advice?
No.
Okay. You wanted to add something, Hyla?
I mean, when asked, we advise, we have given advice. Obviously, the regulation is in 18450.1, and it says an advertisement includes, and there's 2 categories, posters, door hangers, and yard signs of more than 200, and then a billboard is an advertisement. So then we get asked, in this case, it's a 3-foot by 6-foot sign, banner. So is that more like, we get asked these small questions. Is that more like a yard sign, or is that the size of a billboard? So then we apply the we'd advise it's a billboard and it requires the disclaimer. We've been asked the same thing about the 4x6, road signs. They fall more under the billboard where they require the disclaimer. Then,
There's no category in the statute, is that
Oh,
correct?
well, the statute just says advertisements require them, and then this regulation defines
It
what's.
doesn't mention these in-between things at all, right?
Well, they are fitting into these other categories. Are they
And I don't
oversized
really-
print media?
just hold
also
on,
requires
please.
it. Right.
Sure.
And we, when her firm asked for informal advice, they asked about the signs on the side of the road, and we emailed, yes, they require a disclaimer is required. But I think Ashley's point is maybe put it in a reg, but it's our consistent advice. There was a prior enforcement case recently on a similar one. That's what we've advised.
Can I ask a question? Does the I don't have it in front of me and I apologize. I also don't have my laptop. Does the regulation give a definition of what's a yard, a size or not?
It doesn't say specifically on the size of yard signs. It's pretty understood when you click on the companies that produce them. They'll say this is your small lawn sign, your big lawn sign, this is a road sign,
So if they were to change that, then you would change your opinion of what is a yard sign versus what is a
No,
billboard?
we're fitting them into what's in the regulation here. Oversized print media requires a disclaimer. Billboards require a disclaimer. We're always asked the reg is not going to encompass everything and set out the dimensions of everything specifically. Then we're over-regulating and people.
So before
crazy
people
about that.
produce these signs, do you often get the request in advance? Is that the way it works often for your division?
Yes, they'll check whether it needs a disclaimer.
Okay, again, in our regulations, does it specify when it's no longer, at what size it becomes a billboard, I should say? Because billboard to me is something that's like maybe 25 by 50, it's big.
This is Galena West. I would just say that the companion regulation has oversized print media, and that says that it's larger than those designed to be individually distributed. And so that's where the guidance is given as opposed to dimensions. So whereas a yard sign you can stick in the yard, if you need some sort of digging device, an auger of some kind to put it in, we don't consider those to be individually distributed that you can carry away. If you need a truck to take it somewhere, then perhaps it's not a yard sign.
Could we just specify a size, that the size range from this size to that size is in this category, rather than that kind of?
Right, and that's what the advice function is for. So when you write a regulation and you need clarity, then the advice function
Yeah, but
is
we could
there.
be a little clearer in our
Right, and
regulation.
that's how the advice letters, the advice email, and is all there and available for anyone that has any questions. But reg suggestions,
But we're always
It's not a
filling
new
in.
thing.
always
Yes.
open for. That's not a new thing. No.
No, I mean, my firefighters in Torrance, going back almost 50 years, put up 4x8 signs for city council members they like. And so if this is an issue for a 4x8 sign, it should be in the regulations. It's been going on for over 50 years.
So is there some direction to maybe have legal division review the regulation to see if more specificity can be provided?
Yeah, I think that's a very good idea. I think that, we seem to love to regulate, so let's do this one that will be appreciated by the regulated community.
Or won't?
But well,
Clarity is helpful.
yeah, I think the regulated community wants to be able, as we talked about earlier, wants black and white, right?
I didn't say it.
I know you didn't. So anyway, I welcome any other thought. We welcome any other thoughts, but then I want to turn back to this specific case.
Yeah, I'd like to point out that another subdivision says that a disclaimer is only required on buttons and bumper stickers when they're larger than 10 inches in diameter or 60 square inches. So that's really specific.
So we know how to do it.
We know how to do this.
Okay, but I'm going to ask us to go back to focusing on this case, and
Thank
obviously,
you.
if the regulation comes up, she can come back and testify as to concerns and participate in the IP meeting. But if we can focus on the case before us, any questions on any more public comment regarding the case before us? Okay, seeing none, is there a motion on item 4?
No, I want to go back. I have a question now because I didn't know this was an issue. So thank you for enlightening me. What happened in this case? Was this case anything like somebody really just not knowing? What was the reason that these people gave for not having the disclosure statement or for having it be too small?
They really didn't give one. They just said.
Did we
they-
ask? With all due respect, I'm super serious about that.
Right. No, I understand. Generally, we ask them, what happened, and they, most of the time, plead ignorance of any rules, and then say, well, I knew that there were rules, and then I expected the printer to follow them, is generally the response that we get. In this case in particular, they cooperated with us. They didn't really say that they didn't understand the rules. They just failed to follow them.
Were the 2 banners that had the paid for by, were they significantly larger than the 5 banners that had no disclosure at all? Is there a possibility that they just were as confused as we just discussed was possible?
Well, even on the larger banners, the disclosure wasn't correct. So I don't know. I can't
But it
attribute
had
it
a
to it. but
disclosure on it, an attempted disclosure?
It just had a website address.
Okay.
And
Well, it said no on H, yes on I, and a website.
well, it's their message and then a website. Yeah.
Oh, and that, okay.
Any further questions or comments from the commissioners? Okay, is there a motion on item 4? I will move item 4. Is there a
Second.
second?
Commissioner Adaro,
No.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Abstain.
Commissioner Hayward,
No.
Chair Remke.
Yes.
The count is 2-1. 2 yes, 2 no, 1 abstain.
Okay, so that motion, that item neither fails or passes.
I'm sorry, I was rudely talking well. Where does this leave us?
Well, it takes a vote of 3.
So the stipulation doesn't pass.
It's not
stipulation's not accepted.
rejected.
It's not
in
accepted
limbo.
either, right? Okay.
Right. So is there any, I would ask if the commissioners who voted to reject the stipulation have any concerns that they would like to perhaps express, that Enforcement Division can consider whether or not they should attempt to renegotiate this stipulation to address those concerns, so perhaps it could pass. Any comments or concerns that would like to be expressed?
I would feel more comfortable with a lower amount because I think there is, and I learned today, I did not know it before, I think there's some lack of clarity that might have affected this. I don't know. I don't know enough. We don't have an answer for why the problem existed. So I'd rather have it be lower, especially if we have a history of having a lower penalty. How much lower? I don't know. Lower than 3,500, possibly 2,500 or less.
So 2,500, like the comparable yard sign case?
Okay. I guess. I keep coming back to whatever is fair, whatever is right. We have to, I don't know if the 2,500 case is apples and apples. I don't know that. And honestly, I don't have I have not gone back and read every signage case that we have. So I don't know. But I'd be interested in why it is that this problem occurred. And if it is that the group misunderstood the signage rules, then, look, I think that's on us. That's how I feel.
Commissioner Hayward, did you want to add any concerns or direction for enforcement on this matter?
No, I think see a distinction between cases where you've got a tangible item with a disclaimer on it that is wrong but exists, and one where you don't have any disclaimer at all. And so I would give them, in some ways, credit for having the undersized disclaimer, because at least it's there. And if you walk up to the yard sign, you can see who paid for it. Is it big enough so that it can be seen in the way that we've told the state of California they need to put disclaimers? No. So it's not a nothing, but it's, there is some efficacy to that disclaimer, and they shouldn't be treated as though there isn't. That's the only thing I would add.
So just so we can have some direction, are you also proposing perhaps a lower fine on this case?
Yes. No, I would, like with Reed, I think when you've got some but not all kinds of cases, you can enforce the law, but your discretion as to how heavy a hammer you're going to put down on someone is really where you can exercise some judgment.
Okay, so we will move on to item number 5. Which commissioner would like to begin? Commissioner Odero?
Yes, I took it off the list. So I actually just have a question. Very simple. I have no preconceived notions. I want to understand what accounts for the $1,000 difference between this case and the Prop 61 case.
Galena West, Chief of Enforcement. The Prop 61 case was 2 YouTube videos that then got changed as soon as they were contacted by the Enforcement Division, whereas this case had naming problems for their statement of organization, as well as the $50,000 disclosure naming problem and the special economic interest also not in the name. And then had to change all of their different advertisements and everything that they were doing. So there was a lot more going on in this case rather than 2 YouTube videos.
Okay, so just to be clear, I maybe I misread this, but I thought that the YouTube videos were not fixed. It wasn't cured.
They did cure prior to the election in Prop 61.
But failed to timely change the disclosure statement on the 2 YouTube videos is what I'm reading on 5 lines
Yeah.
10 and 11.
Keep reading.
Okay. Sean cured the violation prior to the election by changing the disclosure. Oh, I see. Okay.
Is that it?
That's it for me.
Any other commissioners have comments or questions on item 5?
Well, I wasn't going to set it aside, but I did think that this fine was probably too low considering the taxes that. I did think that, I didn't ask that this be set aside, but I did think that the fines were kind of low considering the facts as they were summarized in the in this proposed decision. It seemed to me that the ultimate disclosure that should have been made that would give the voting public some clue who these people were wasn't made until literally all of the material was out in the public's hands. And it was by a variety of media that they were doing this. But to me, when they amended this after the fact, it had no meaning at all. I just felt that maybe they, they might have gotten away with something.
And in fact, I think they did, right? Weren't there 2 billboards that they weren't able to fix?
Yeah.
Any other questions or comments from commissioners? Is there any public comment on item number 5? I believe there Are you just submitting a letter?
My comment is actually,
Would you please just step up to the mic so we can all hear you? Thank you.
yes, and I don't know how related it is to item number 8, and I'm no a bureaucrat, and I don't know much about the nuances of politics. And I thought it was number 5, but I think it is number 8 because it's a fine against Sam Action.
That would be number 8. Do you want to hold
Okay.
off then?
I will hold off to number
Okay,
8, and I
good.
apologize
No,
for my
that's okay.
mistake.
It was a little confusing because Sam is named in 5, but it's really the respondent in number 8. Okay, any other public comment on item number 5? Okay,
Hi, Ashley Titus again, and this committee was a client of our firm. And I just wanted to give some context to Commissioner Hatch that the real issue here was disagreement between the committee and the investigator as to the requirement of including the name of the major funder's name in the committee's name. And that was sorted out where it was understood that the requirement isn't that the name of the major funder be amended into the name of the committee, but that the economic or special interest of the major funder be amended into the name of the committee.
Mhm.
And a continuing disagreement whether the major funder has an economic or special interest, being that it is a nonprofit organization with no economic interest whatsoever in the issue. And so there was some disagreement about that. And to appease the investigator, the amendments were made and a settlement was reached. It's not necessarily, again, that the committee is entirely happy with it, but the committee would like you to adopt the stipulation.
any other public comment on item number 5? Okay, is there a motion on item number 5?
Madam Chair, if I would like to ask the committee to put this over a month to give the staff a little more opportunity to look at it, see if there's anything that they want to revise. I don't want to give direction, but I kind of think that there's an opportunity to take a look at it and see whether they got everything.
To look for more violations?
But to look to see whether you got what there was there.
Well, I never had a request to reopen an investigation, and that I think is fair to say we do not have the authority to direct to reopen an investigation that has been presented as a case. But I'll let our general counsel.
To be clear, I just asked that the matter be put over for a month to give them an opportunity, if they wish to do so, to look at what they have.
I see. I guess I'm not clear because right now, I just want to kind of be clear for the record so we know what we're doing. So right now we have before us a proposed resolution to vote on yes or no. You want to make a motion to put it over
Put the matter over, period.
and just leave it at that.
Yeah.
And it will come back next month in this form.
Or any form that staff wants to present it in. I'm not going to tell them what to do.
Yeah, I'm confused too, because we either reject it and they go back, or we, I guess, don't vote on it, but then it doesn't change it at all. It'll still look the same next month.
Right. So right now, this is the pending stip. If you want to make a motion to reject it again with direction of what you would propose to be being brought back, just to not vote on it with it's still there.
Well, we just did that on item 3 last month. Was back.
No, we had a
before us.
vote and it didn't pass. That's the difference. So we need to take a vote
It was put over.
because it didn't pass, because you need 3 votes to pass.
Oh, I thought they voted to put it over. I didn't know that. Okay.
So is there a motion on the stipulation as presented?
I move approval.
I second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch,
No.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay. We'll move to 7, and I'll ask Commissioner Odero if she'd like to begin.
Give me a second. I have to.
Okay. Any other?
These
Well,
are just going very
sure.
quickly.
While you take a moment, do any other commissioners have questions or comments regarding item 7?
Madam Chair, I had some questions that I covered with the General Counsel a couple of days ago by phone. And I think I'm pretty satisfied with where this is. My questions to her were, what's the material difference between filing as a slate mailing organization and filing as a regular committee? Because they were filing. They just were filing as the wrong thing.
Very good question.
And I learned that when you file as a slate mailing organization, it is clearer what campaigns and candidates are being supported and opposed, and which ones paid, and by implication which ones didn't. And so rather than having just a general purpose committee report where you've got receipts and disbursements, there's more of a coloration to it, because you can actually see that particular receipts were because you were advertising them on your slate mailer.
Right.
And I think, for people who aren't involved in the arcane world of slate mailers, this is not abundantly clear. So anyway, I want to thank the General Counsel for our lovely phone call the other day that was straightening me out on some of this stuff.
No, that's a good clarification, because I think the issue is it's something we talked about earlier, whether there's disclosure, is disclosure sufficient, but there is a distinction here in what was not disclosed, and it was particular as to whom paid for to be on it.
To be on and on.
Right.
I would say the other distinction is that in this case, I believe it's a city committee, and so they file in San Francisco. But when they file as a slate mail organization, they file also with Secretary of State, and then all their campaign statements filed as a SMO are online with the Secretary of State. So it is a difference on also where you file.
Did you have any further questions, Commissioner Odero?
Yeah, I'm just curious, is this a situation where it might be an opportunity for us to go out and do more training? Because it seems like in one of them, they were missing the notice box, and then they were missing the little asterisks. And then in the other one, they were missing the notice box. So this tells me something is going on that somebody doesn't know. And then also, is the difference between the comparator of $1,750 for the comparator, which was the parent teacher something voter guide, and these two counts where they're at 2,000 each, is that because the mailer reached more people? Is that our standard?
We also, in that comparable, they halted distribution when they discovered their error, and so they didn't distribute all of them once they figured out that I had the wrong disclosure.
So they distributed 6,000 and didn't distribute more, or
No,
they distributed,
they stopped.
halted?
They halted the 6,000. They ordered 6,000 that were incorrect, and then they didn't distribute them all.
So that's a good fact for us to know. So that's good. That's helpful. So it is about taking a proactive step, but that presumes that these people knew, right? They knew that they had done it wrong. Do we know what do we know what who's number 7, the San Francisco Latino Democratic Club? Do we know that they even had any idea of the law or the requirements? And I understand that they have to come up to speed with the law. I get that.
But they're paid to do this. That's a big distinction.
Yeah, when people, I mean, I don't know what this
Yeah.
club knew, but when people are sending out slate mailers, they generally, this had a lot of candidates and measures on it. It wasn't the case if it's a joint mailer with 4 candidates, becomes a
Okay.
slate mailer inadvertently. Usually people are aware of the slate mailer disclaimer requirements. It's usually a
Okay.
sophisticated
Fair enough.
bunch that are sending them out.
And paid to do so.
Because you're
Fair
getting
enough.
paid to do so.
Okay, any
Somebody got their money back.
any further comments or questions from the commissioners on item 7? Any public comment on item 7? Is there a motion on item 7?
I move approval of item 7.
Is there a second?
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
I vote yes.
Oh, okay. I know what you voted.
Okay, so item 8, we'll start with comments from the commissioners. You ready?
Now we're going to read this one. Somebody else go first.
Any other question or comments from commissioners on item 8?
I feel like I'm at a restaurant going to start over there. But okay, I at least know my my appetizer.
I'm
So I'll
glad you guys talked first. Let's just say that.
And this is the one, just to clarify, from item 5, which I found confusing. And I know it was confusing while we were doing our top 10 contributors list, who was paying what. In item 5, Sam was not a respondent. In item 8, Sam is the respondent. Okay, so I'm just stalling, really. Is
No,
what I'm
okay, that's fine.
doing.
No, I can. What is the? We had no comparator. We have no history at all of somebody failing to identify the top 10 contributors. Is that right?
It's pretty new. I think it went into effect 2 years ago, 2013, and it only is for $1 million. So generally, the people that get $1 million comply because they have a sophisticated staff, and so you don't get a lot of violations of the top 10 contributor list rule because these are your more sophisticated parties.
So how did you come up with 2,000? Because I don't see anything in here about that.
Well,
Maybe I
what-
missed it. But.
We just tried to look at other disclosure issues and compare it to things that were disclosed on other reports. So because since the top 10 list is a compilation of information that's disclosed elsewhere, but yet put into like a user-friendly format so that people can understand it on the fly as we go up to the election date, then we went to a lower fine area for comparable to cases where the disclosure is also available somewhere else.
Okay. That would be helpful to have, just because I think the public reads these things. I think it's helpful to have your reasoning.
Okay.
But I'm glad that you provided it here.
And by not submitting the top 10 contributor list, there was some, or it wasn't as easy to find out some information that we would have found out had it been on there, like the top contributor to this particular proposition, right? Isn't that with the trust issue?
That's true. On page 5, it says that they turned out to be the second highest amount to the statewide to oppose Prop 64. And once it was compared to the other lists and compiled.
Which is kind of the goal of the top 10 contributor list, to have it in one easy spot so we can compare the overview of these measures. Any other commissioners have questions or comments on item 8?
On count 2, so we're looking at a few factors, right? Whether it was within or outside the election cycle, whether ultimately it was even disclosed before the election, right? And it seems to me that this particular case is not as egregious, and I use the term lightly because, anyway, is not as bad as the comparator, which was Measure U, where, as I understood it, Measure U was within the election cycle. So can you talk to that a little bit?
Certainly. So the Measure U case was 6 contribution reports for 70,000. And those were within the election cycle, and these were not. So these were substantially higher amount of money, but yet not within the election cycle and disclosed before the election. So those are the factors here. And then the factors over here, there's more money and then less money in the comparable, but these were right before the election and these weren't. And then these were disclosed before the election and these were. So we did find that it wasn't as egregious because it was reported before the election, and therefore it was 1,500 as opposed to the comparable at 2,000.
Okay, so it's about getting more information out there sooner.
Right. Always about disclosure.
Thank you.
But they were given before the election. Did I misunderstand what you said?
They were given and disclosed.
Both before the election.
Yes.
Any other questions or comments from the commissioners? Is there public comment on item 8?
I would like to speak because in this item.
Sure. Can you just start by stating your name?
Okay, my name is Julie Schauer, and I wrote, as I gave to you on it was item 5, but it's item 8. And I object to being called, Sam Action is accused of not identifying me as an economic or special interest. Okay, and I object to being called an economic or special interest very much. And being called that is just false. It's an outright lie. I am a person who has no financial interest tied to this issue. I don't invest in pharmaceutical companies or treatment centers or private prisons or any of the businesses alleged to be preventing marijuana legalization. Politically, I'm an independent, totally independent, and I don't normally donate to candidates, and I don't get involved with many political issues other than this one. And I'm being used as a scapegoat for the shady practices that go on in the state that are donating to marijuana legalization, and they're totally shady. And it's all, it was put out in an article, and I think everybody knows it, when $12.5 million comes directly from the marijuana industry, and 11.2 million of that in state from people who have businesses invested in marijuana, and they don't have to disclose their name. Well, they treat me like I'm some kind of tabloid person because I donated money to Sam Action, which was supposed to go to 9 states. Okay, and so I get journalists coming after me. I get my name, I get publicly defamed, so I can never go back to college teaching again, which I was doing for nearly 30 years, because they have damaged and tarnished my reputation so much. It is just despicable. The humiliation I've gone to, people I don't know finding out, my phone number, or somehow getting a hold of me and email and harassing me. And because the marijuana lobbyists love to put people down, what they said about me as a teacher, I do think most of my students would say I'm a good teacher, but I will never go back to teaching again. I mean, I'm not going to say that I economically depended on that, but I was doing a public service as a community college teacher, and they can take if they could dig up nasty comments about me, and they can take that and turn that into public humiliation. So I have to have the internet doing a number on me in the marijuana community. Hopefully not, but if anybody wants to look up something on me, they can find this and they can see those same things. While the people who give to the other side get scot-free, I am a scapegoat for a very, very dysfunctional thing. Now, as far as Sam Action and the fact I gave to 9, I wanted it to be given to 9 campaigns. Okay, and I am known to have strong feelings about this. I have very strong feelings, and as I say, I have 3 friends in California whose kids have been torn apart by marijuana. One of Lori Robinson's son is dead from a suicide from marijuana, and marijuana led to his psychosis, which eventually put him in the mental health system, and he committed suicide. And the story is online. Mom Strong has published that story. I think it's the more of it is coming out. Two other friends, a college friend of mine has two sons. As soon as they got 18, they got their medical marijuana cards. One of them is not addicted. The other one is in his third, and now it's a long-term treatment for addiction. There's no chance. I don't know if he's ever going to recover. Another friend has a son who went psychotic from getting marijuana edibles. As soon as when he got to college, he got it at his very fancy California college, but he got it as an 18 or 19-year-old for insomnia. He got a medical marijuana card. He got edibles. He had a psychotic break. He has been in the mental health system. Now he has had all kinds of problems. Both these, okay, so one friend with a son dead, two friends with sons that you don't know what their future is going to be like for them. Untold youth damaged by this. A state that cannot regulate its medical marijuana does it, and has had 20 years to figure it out, and it's only gotten worse. Is not going to. That's the interest, to save people. If that is considered an economic interest or that is really sad. And I would say, when I read about this, I am not talking on behalf of Sam. I did come across, the country to say this. And I didn't deserve any of the humiliation, any of the embarrassment, what it did to my family, and how it hurts me. Nobody would want this. And I'm the only person singled out, while these other people, I know Sean Parker, made his name public, and he gave $8.5 million. This system, and I found out in the process why Californians who were against this wouldn't give against Prop 64, because they know their reputations will be tarnished. They know their kids will be in danger, or their grandkids. They know that if they give 500 or 1,000, they could lose their jobs from it. And I did read online that people lost their jobs when they're on the wrong side of one of these ballot propositions, because you can get publicly humiliated for it. And I got public humiliation, and other states, I have to admit there's fear, and I am rambling on, and not as much as this, but other states at least got people.
And I don't want to cut you off. You did submit 2 lengthy documents that will be part of the record, but I do need you to start to wrap it up, and then perhaps you can focus more on the case before us if you have concerns regarding that case.
Yes, I will tell you. I do not understand. Okay, first of all, Kevin Sabet, I told him I wanted it to go to all the states. Money I gave. I don't know how it ended up, but there were 9 states. He probably feared most of it had to go to California, because Californians are afraid to give because of what happens to them. He did not know at the onset that if you gave to a committee that was going to give to 8 other states, that it would still have to go down as coming all from one person. But what I object to is why the people who gave to this network of political action committees and funds like the New Approach PAC and the Drug Policy Action PAC, and many people, several people besides Sean Parker, Carrie Tuna gave $2 million, George Soros gave $4 million, the Lewis family gave $3.5 million. None of them get their name on Ballotpedia or in the Secretary of State's office. To me, it appears like the Secretary of State's office wants to make me the scapegoat for everything. And it is a humiliation. It's a public humiliation because of the way I've been treated. Press hounded me. I did convince one editor please stop, your reporter from prying into my life. I don't deserve that. All I wanted to do is protect people and not have a proliferation of drugs around the country. And I do not deserve to be treated badly. And I am not an economic interest. And I had the other small thing in giving to Sam Action, I had no say about advertising the course of that. Sam Action gave to No on 64. If I wanted to give to No on 64, I could have given online to No on 64. Sam Action has a broad educational purpose. Sam Action. Sam Action also, educates, considers itself a middle ground. It doesn't consider itself one way or the other. I think it's all unfair. I think it's damaging to Sam Action, but I mostly object of what this did to me personally. And
Okay,
it took
I'm
some
gonna-
courage to come here.
Well, thank
But
you for your
look-
testimony and thank you for
Look at
coming.
this, 35
And
million,
that's part of this
36
packet. What you're
million.
pointing to right now is part of the packet, which as I said, will be made part of the record and posted online with the agenda.
And I want to make sure.
You
This-
can speak. Can you deal with this with our commission assistant afterwards, and you'll make sure she has everything you need her to have. Thank you.
To the chair, one question.
Yeah.
Do you feel that there's any misrepresentation as to what you contributed to Sam Action in the record?
Okay.
In our record?
I gotta say, it's very painful, and I started trying to go through it and verify, and I stopped because I honestly couldn't deal with being, everybody feeling that I personally have to be put on display. I can't tell you, but to say that it was for California is just false. All of that. I would say to say the money that I am alleged to have done is listed let me see, knowing that I was intended for California, they list about 12 times as much as I intended to go to California. And that's how it's listed in the Secretary of State's records and in other records. Okay.
It's a separate issue from this.
And I don't know where it all went. I mean, I don't know what was allocated, because it went to Sam Action, and Sam Action was taking funds from other people too.
So you donated to Sam Action.
Right. I donated to Sam Action.
And not directly to the campaign.
No, never directly to No on 64.
Have you actually seen this stipulated agreement with Sam Action over what amounts were given?
No, I didn't.
She's not a party to the agreement.
I understand that she's not a
Okay.
party, but she's.
No, I know. I'm just that's.
Her
I didn't
donations
even
are
know.
likely
I
to-
didn't even know it was coming up, and they didn't tell me when I read about it in the paper. Yes, because I did look. Then I did contact, and I did say that this makes me angry again, and I'm going to go. And I heard a week ago, and I said I'm going there. I can't.
Well, thank you for your time and coming to testify. And like I said, it will your documents will be made part of the record as well. Is there any additional public comment on item 8? Is there a motion on item 8?
Well, I have a question. Does enforcement have any comment on everything that was just said?
Every campaign is very contentious, and we take privacy into consideration, but we follow the rules of disclosure. We worked with the committee to find out exactly what disclosures were required, got documentation to show that, and that's what's reflected in the stipulation.
Any additional questions, or is there a motion?
I just have one additional comment, because I'm not sure if I
Okay, but if it's in the report, it is going to be part of the record, and we do need to move on. Most public comments are limited to 3 minutes. Thank you. Okay, so is there a motion on item 8? I'll move item 8. Is there a second?
Second.
Commissioner Adero,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
This motion passes.
Thank you. Okay, we'll move on to item 9. And commissioners have questions or comments on item 9.
Well, this was one that was pulled by my colleague, but also one that I was going to want to talk about. So maybe I'll give Maria a break and start on this one. I would like to talk about the same issue regarding both item 9 and item 36. They're both defaults, as you will see when you flip through. They both involve penalizing respondents in default, I guess they're still respondents, for failure to pay the annual fee and then compounded failure to pay the penalty on the annual fee. The annual fee for those in the listening audience is $50, and the statute specifies that the fine for not paying that fee is 3 times that, or $150. Now, so we've got that. Then we've got our regular or throwback penalty of a maximum of $5,000 per count. That's in section 91005, which I don't have in front of me because I didn't bring that book, but I wrote it down. And in 91005, it says that that penalty doesn't apply when the penalty is provided for elsewhere. And the problem I'm having with the way we approach the annual fee cases is it seems to me pretty evident from the text of the statute that the penalty should be capped at 3 times the annual fee. And that it shouldn't ever be subject to the potential $5,000 fee or fine. And that just seems to be what the print says. And so I pulled those with the idea that I feel pretty strongly about this. And they are defaults, which means that we can modify the penalty. So I'm going to go right out there and say that my motion is to modify both these defaults to reflect a maximum penalty of
Can you just hold on your motion till we have further discussion so everyone
Okay.
has a chance to respond?
Oh yeah,
So,
no, I'm happy to. It's just sometimes if you get it out there, and everyone is talking about something specific rather than something else.
Okay, so you're going to want us to
I'll-
revisit that.
I will.
thing,
I
totally.
will sit on that last
I
sentence.
just want to consider discussion and public comment before we
Of course.
make
Okay.
a motion.
So
Thank
so
you.
anyway, that's why I'm pulling them. I'm pulling them because I read the statute in a way that's really, really different from how we're implementing it.
Okay, great. Galena West, 91005 is the civil penalties under the Act. And we actually are prosecuting this under the administrative sections. So the applicable section would be 9100.5.
That's 5.5.
91000.5.
91001.
91000.5.
Okay.
91,000.
And Miss West, for those of us who don't have our act in front of us, can you kind of just read the highlights of what you think is relevant for this discussion?
So what Commissioner Hayward was referring to is our ability to do a civil action. So yes, under civil action, we're precluded under certain things that we can take, certain things we can't. And in the enforcement sections, there are many, many sections that have different fines within them for the civil actions. So reporting is up to the amount reported, or the conflict is 3 times the amount that you gained. And so they all have kind of different parameters that are set up. Where under administrative prosecution, it's just that no administrative action shall be brought under Chapter 3 alleging a violation of any provisions of the title, and it should be commenced more than 5 years. So that takes you back to Chapter 3, which is our administrative prosecution ability. So under Chapter 3, you look to 83116, which is the violations of the title. The violations of the title say that, and the liability for violations under 83116.5. Any person who violates any provision of the title or who aids or abets shall be liable under the provisions of this chapter. So it encompasses everything within the entire title, which is the act. So by placing annual fee into the act, they made not filing your annual fee a violation of the act. So the purpose of that is, if they did not want it to be a violation of the act, they would have put it in the elections code, or they would have put it in a different code. The reason you put it into the act is because you want it enforced. So subdivision D, or I think it's, let me get the exact subdivision. It's under 84101.5, which is annual fees, says that a committee that fails to pay a fee is required subject to the penalty equal to 3 times of the fee, and then the commission shall enforce the requirements. So yes, it does give a specific penalty that goes to SOS. So that is what we are enforcing for them, but it still remains a violation of the title, which is the act, which is what the administrative action is about. So it goes back to Chapter 3.
And just to clarify, when you say the $150 penalty goes to SOS, in fact, isn't the process that SOS charges the $50? That's their fee. If they don't receive it, SOS attempts to collect the $50 plus the $150 penalty.
Right.
It's when that doesn't occur, where SOS cannot contact the person or obtain the fee and penalty, that it's referred to us. And at that point, it becomes an enforcement action.
Correct. And so if you read it the other way, there is no reason for it to be in the act. There is no reason for it to be referred to enforcement, because SOS has already instituted the $50 fee plus the $150 fee and gone through their own collections, which is what they can do, which they do for their filing fees. But when it comes over and becomes a violation of the act is when enforcement can then enforce it. Because if you read it any other way, enforcement can't even doesn't have any even mechanisms to enforce it. We don't even have an administrative action protocol to follow if there's no reading of it as an administrative action.
I guess I don't have a problem continuing to read it as an administrative action, understanding that the penalty is capped by the annual fee statute, which was passed after the administrative penalty 83116. And, you know, if you're doing statutory construction in law school and you talk about the last in time doctrine, that's a pretty powerful argument that the cap is $150.
But that's the cap for the SOS portion.
Where does it say that?
It doesn't say that, but read it in its entirety, then it's the $50 fee portion that funds, and there, I believe there's a companion legislation that says that it goes to the fund, and then the $150 goes to the fund to fund the new Cal Access. And so that $150 is the extra money to the fund if you don't pay by the deadline.
Yeah. And I it's not that your argument is unreasonable. I just don't think it's the correct one. Has this been litigated?
We've never.
Nobody's tested this outside of our.
Well, and we just, again, as background, in 2015, as part of our streamlined program that the commission reviewed and adopted, we installed the tiers for penalties. That's, again, when someone does participate. So again, once it becomes, it's a referral over here, it's an enforcement action for someone not complying with the act. And we said, understanding that it's a $50 fee case, $150 penalty if you comply. So I think it's $200 is the first level. I mean, but anyhow, so it's, as of 2015, we have adopted that this is part of the enforcement action, and we have been collecting the fine accordingly for then, I guess, going on 2 years now as to whether or not, and I don't think it's ever even been challenged.
Yeah, and I guess when I see that degree of sort of nuance in the streamline cases, I'm like, awesome. But, you know, again, because we're looking at defaults, we're looking at people who are getting slightly more hammered in the, not in the, it's April 20th, not in the 420 cents, but in the sense of being charged large penalties. And I think we're wrong. Sorry.
So you think,
meaning no disrespect. I don't
you don't
see-
think we should have any, I just want to be clear on the amount or any penalty. So it should be referred to us to be the collection agency for SOS?
I don't know why it's written like that. I don't know what the legislature was thinking. All I'm saying is that when I read the plain text of the act, I see a cap on penalties for failing to file annual reports that's 3 times the penalty. And, you know, we've got an interpretive gloss on that, which I think in this building made a lot of sense. And I'm not saying it doesn't make a lot of sense. I just don't think it's correct. I think, you know, the legislature capped what someone could be charged with missing a penalty, and then gave us enforcement authority to, I don't know, because they didn't think the Secretary of State would do a good job. I have no idea. I'm not saying that. Please, out there in Cal Access land or whoever you are, I'm not saying the Secretary of State's a bad person, but I don't know.
I guess
Maybe there is there legislative history on this? Maybe I should look there, because I just don't see this reading as being the right one.
We've looked into it in the past and have felt comfortable with our interpretation with the legislative history, because the whole point of the bill was to have the Cal Access fee plus penalty and to have enforcement to be the power behind it with a violation of the act. So if that's not clear in the legislation, then I think it was
members
always-
would have heard by now.
I think that would be.
So the clause 2 that says the commission shall enforce the requirements of this section, in your mind, and the interpretation of this agency has been that just flips it into the regular.
Well, once you put it into the act, it becomes a violation that is administrated under Chapter 3.
Mhm.
So the whole point of putting it in the act would be to make it a violation of the act if you don't comply, because otherwise you're putting it into the act for no purpose. So you put it into the act with a 2/3 vote. So the only reason that you would do that is with a purpose, and a purpose cannot be for no reason.
And it's somewhat similar to the late filing fees that the clerks can collect on the campaign statements, the $10 a day, $20 a day. But then we can bring enforcement actions if they aren't.
Once it's
filed.
referred to us for noncompliance at the clerk's level.
Right.
Then it gets referred, and then it becomes another thing.
Does the failure to pay those noncompliance fees become its own violation, in our view?
No, because of the underlying violation.
Okay.
It's written somewhat differently, but it's similar in that how it is referred to us.
Okay.
This is the only payment under the act, which is why it is a struggle, because it's the only thing that is requiring someone to pay something rather than file something. And so that is the difference, but it's the only difference.
I think it's kind of a big difference, but I'll leave it. Thank you. You've answered my question. I think understand a little bit better where we're coming from.
Commissioner Odero.
Thank you. Let's assume, arguendo, because I'm not going to opine one way or the other, but let's assume that your interpretation is correct. And let's now come to the amount of the penalty. I think the amount is outrageous. I think we have taken $600 and converted it into $9,000. I can't even imagine that that's constitutional. I think that's wrong.
Ms. West, do you want to just comment on, so I think you've on these default matters, as we've done in prior months and approved it recently, you've done per fee at 3,000. How did you get to 3,000 for a default case?
Well, that's been the commission's direction. Enforcement has just been following the direction of the commission. And so if the commission has decided that the fine should be lower, then they obviously have the
Fair
power
enough.
to lower. So we present what, I mean, as I said earlier, we look for direction from the commission because we want to bring things to you that you vote yes on. So this has been the direction of the commission. This is consistent with the last 3 of these cases that have been presented to the commission
As defaults?
as defaults.
But now, I guess, again, my question is a little bit more specific. How did you derive at 3,000? Is that in correlation to what? With the Streamline program? Or what's the?
Sure. So since the Streamline program caps at 1,000 and then it's plus the $200 that is owed to Secretary of State, the default started at plus 1,200. So 1,200 is the most you can have ever in a settlement for one count. So it had to be higher than that in order to make them pay it. So it was anything higher than 1,200 was kind of the enforcement mantra when it came to a default, because then that way it's more than what you would have gotten in your worst settlement offer.
If you cooperated and
If you
signed.
cooperated and paid the fee and came up to
So if
date.
you cooperate and pay the fee, but I think as I recall the Streamline memo, it's very late in the process. You've been contacted now, probably going on 2 or 3 years.
You're about to go to hearing
Yeah.
for $1,000.
So then that's $1,000 if they're willing to pay the $50 fee, the $150, and then $1,000. So you're saying that the rationale was if the highest you can do by agreeing to do this is 1,200, definitely a default should be higher.
Definitely default should be higher. And just for the record, if the commission would like to make legislation to take this section out of the act, I'll be the first one to sign on.
Yeah, it has been a huge burden, I know, on the office and a lot of time over the last 2 years because I'm going to, it's probably in the report at the end, but I'm going to, it's like 2,000 referrals we received.
4,200.
Yeah.
It is kind of a
Yeah.
one-time thing. The initiation of this fee for committees has cleared out a lot of the old committees that were dormant, and they administratively terminated a lot of ones with low activity. So it shouldn't be such an ongoing.
Which is part of the
Problem.
purpose of the whole program,
fee.
though, right? It's like we had 4,200 committees registered at SOS that were no longer responding, participating, and the issue is that's a lot of dead weight to get through the information that we want to get through.
Right.
All right, Commissioner Hatch.
Yeah, I had a question procedurally. If we were to approve this, which may be in doubt, the money that is proposed to be collected, is a portion of that allocated to the Secretary of State's Cal Access program, or we keep it all and send it to the general fund?
If we ever get money from default, then we do a portion because we're required to collect their fee.
Okay.
So if say they only send in $200, then that's where it would go.
Okay, so if we collect the 3,000 per, we take the 50 plus the 150 for each of those. Okay, thank you.
Which is a good point not to lose sight, though, on these defaults, and now we've talked about it before, is the fact that since the person has not participated, since we are forced to go through the default process, and I think the Enforcement Division's doing a fairly good job of listing the number of contacts that have been made on some of these cases. On this one, it's on page 6, a summary of contacts 25 times.
Wow.
There's no guarantee we're ever going to see this money, and we still have to go through the collection process. I mean, it's not to say that means sky's the limit. It goes back to the point that I believe part of the incentive to be high on default matter is to encourage participation in the process, which these people are obligated to do.
So
Wow.
are we obligated to do the enforcement on this? Because, I mean, I question calling somebody, forget number 9, because you were calling people for other things, right? You were calling that respondent for, not filing their semi-annual statement. So, and there's a lot of money in there. I get that. But 25 calls for $600, I question.
A lot of it includes SOS, though. It's like before the referral, then us. I mean, it's like
Okay,
two
so it wasn't
departments.
us. So it wasn't us that did the 25 calls.
so
So,
alone.
okay.
We
So,
probably
so
did
let's
20.
just talk about what we did,
Uh-huh.
which is what appears to ratchet up the amount, right? But why are we doing this to begin with? If we're obligated to under the act or under the regulations, then maybe we need to revisit it from that end. But just seems like a waste of money to me.
The way the statute was written, it says the commission shall enforce the requirements of this section to collect annual fee.
Okay, but there's a lot of shall enforce, right? But we
Right.
still have discretion, and we know that because we don't.
Well,
my conversation
here's-
about discretion, right?
So here's the rub. So default cases are two ways. There's a lot of thought that a default case, when somebody stops participating, then you make the minimal effort and then just push it through and don't bother with it. Just go straight ahead. Do your 2 contacts and then go straight ahead. But what has been happening with the commission in the last couple of years is the commission's been requiring more and more and more from enforcement staff in the way of contacts and attempts and trying to, in fact, we got pushed back last year on an SCI non-filer. Did you call relatives? Did you call people that they worked with? Did you call the commission? That they serve on? And so as the pushback has gotten more and more and the commission were requiring more contacts before a default would be approved, then, and we had respondents that didn't respond for 3 years that would then write a letter to the commission at the last moment and then say, okay, yeah, I'd like that first offer from 3 years ago. So defaults kind of evolve into these very time-consuming, personnel-heavy actions because they end up taking so many contacts. So as we try to not only, because now we don't just send letters, we email and we call. So it takes a lot of man hours.
But why start it to begin with? I guess that's my question. Why start even the enforcement process, let alone let it get to the default process and then continue through the default process? And maybe I'm just not understanding, but it seems to me that we're constantly talking about limited resources and, to spend ungodly sums of money that I imagine this has cost of your time and your staff's time. Over $600 to me just doesn't make sense.
Right. And I think it's just because it was required under the statute. The legislature was very excited to have a money source for the Cal Access program. And by putting in that enforcement shall enforce it, then we were required to at least do some due diligence. And due diligence for us is the administrative process.
So you're saying the shall enforce in this context means we have no choice, but the shall enforce in other contexts, which I think we shall enforce everything in the PRA, right? And we don't.
I don't know if this answers your question a little bit more, Commissioner Darrow, but the chair mentioned too, it's in the enforcement division report. It gives a little bit of a summary of the referral years we got so far on the $50 fee, which are 2013 and 2014. And it kind of goes through, and I think this might just help. We had, for example, 2460, so over almost 2,500 committees that were referred over for the 2013 year. And it goes through the different, and I'm sure Galina could provide additional numbers for you, but there were some cases, there's several hundred of them where they were administratively terminating the committees. There's some people who got warning letters. So I think Galina and her staff have culled through that giant referrals that we got and handled those in various different ways depending on the circumstances of the cases or the committees. And so I think, again, just maybe as background to kind of what you're asking,
Yes,
I think
that's
to the
helpful.
extent that they could resolve those cases in a different way, whether that is, again, administrative termination of the committee or a warning letter, those were then dealt with in that procedure. And as we get, and then you're seeing, obviously, I think, several months ago, there were more $50 fees on the cases on the agenda. We're getting down to sort of the meat of it for those prior years. We're still going to be getting additional referrals for 15 and 16. And so, but anyway, so I think they did do some sort of culling of those committees as they came over.
It's a good point, because we also, if they're no longer in office, if it seems like the committee hasn't been active, we have a regulation to administratively terminate those committees to get them off the books. And basically we're just contacting them to see if they're even active and saying, hey, are you really a committee? It says that you still had $4,000 on the books in 2012. Could you just tell us what happened to that money and call it a day? And yeah, exactly. They're like, what money? But so unless they give us any reason to be suspicious, then generally those cases do go away.
But suspicious of what? I mean, what is this horrible harm that we are correcting in the world out there at a rate of, I don't know, 15 times the harm?
No, the
I still
only
see
thing I meant was that if you have a large cash balance that you haven't attributed to, and you're the only one in charge of the general purpose committee, then we would like to see the bank statements on where the money went for personal use purposes. If you got a new motorcycle.
That's good. Tell me again how you got the $1,000 that you then add to the 200 to make the
Sure.
minimum. I'm sorry, I don't remember. I don't think I registered what you said.
So that's in our streamline memo from May 2015 that the commission approved.
Right,
So
but just
right. So then it has the tiers, and the tiers for annual fee end at $1,000 once you have compliance before the adoption of a default decision.
And they start
So-
as low as what?
200. So then if $1,000 was your worst case scenario plus the 200 that would have gone to SOS for the 50 plus the 150, then 1,200 is really the bottom low for default.
Even if they were responding.
well, but
Right.
then you wouldn't have a default.
Just pay your $50 fee.
Okay, so just to clarify, if we can focus on 9 first. And so we're discussing number 9. If the commissioners have any more comments about number 9, I understand that the $50 fee is definitely in there. But then we also have the issue of failing to file semi-annuals for, I think it looks like 3 years while in office. And I do not believe we ever got those. We obviously didn't because it's a default. So any more questions or comments on the default? Commissioner Cash, are you still there?
Still here. No comment.
Hanging in there.
All right. Okay, so then let me just ask if there's any public comment before there's a motion. Any public comment on item 9? Okay, seeing none, I do believe there was a proposal motion on default.
Thank you, Madam Chair. I would like to recraft the.
Can I just ask a favor? Because I think, give me a little explanation of where you're going before it's just a motion that we have to then second and vote on, because for a little bit of a discussion.
Yeah, all I want to do is recraft the penalty requested to reflect the fact that they didn't pay the $50 and then they didn't pay their fine, and so all of those would be capped at 200, because under my reading of the statute, that's all we can really justify asking for. And I understand the shall be enforced clause argument. I'm just not sure I join it.
Okay, so now if you could just, so the motion is you move to approve the default.
Yes.
At,
See, I'm trying to find now
Yeah,
So it'd
the
be counts
penalty
9,
part.
10, and 11.
Yeah, so it's
would be
9, 10, 11,
reduced from
and
the-
so those would be 9, 10, and 11 would be $600 instead
Total.
of
9,000.
9,000.
so no additional.
I wouldn't change any of the other counts.
Right, and no additional fine at all on the $50 fee other than the $50 fee and the 100.
Yeah, because I think the 150 is all we get.
Okay, well, we
Is
don't
that
get
what it
anything.
But no, I know, and I know if this sounds like counting the angels on the head of a pin, it might be in this context, but it's a principle that I kind of want to push and get
Okay.
out there in the public.
So it'd be 32,600 would be the total
default.
But they're also just, that's why I wanted you to clarify. So the real issue here for you is lowering the $50 fee because you think legally we are limited to $200
Yes,
per thing. Okay.
that's
So that is the motion. Is there a second?
I second with an asterisk that for a
enthusiastically.
different reason, but I second the motion.
Okay.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch, Commissioner Hayward,
Yes.
Chair Remke.
No.
This motion passes.
Okay, so the next item was number 10. Commissioner O'Dara, would you like to start?
Yes, thank you. I just want to make sure that I understand the difference in a default for filing a late semi-annual statement. If you file it electronically without paper, it's $3,000. If you file it electronically with paper, but they're both late, is $2,500. Is that right? So filing the paper costs you, failing to file the paper costs you $500.
Based on the comparable, is that what you're saying?
I think so. Hold on. I think so. Yeah, I think it is. I think it was based on, yeah, so Mendez was 2,500. But this one is, I believe, 3,000 for failure. I think I've got this right. And the
Yeah.
reason is that it was filed, they were both filed late, but this one was filed electronically late and no follow-up paper filing. Am I reading this right?
I think that it's just written in a confusing manner, the comparable. It's because I don't think that that's what it was for Mendez. I think Mendez was lower because one was filed timely. The Mendez case, the paper statements were timely, and in this case, nothing was timely.
So this one says, however, a penalty of $3,000 per count is recommended for counts 3 through 5 because Denny and the committee did not file the paper statements as was done in Mendez.
Right. So I think that in Mendez, the paper statements were filed, but in this case, the statements were filed very, very late, months and months and years late, but in one form. So the difference being the timing of what was filed.
How late was Mendez?
I don't have Mendez in front of me, unfortunately. I think it's the one case I didn't print out. I do. I told someone today I need a Surface Pro up here.
You know, speaking of hyperlinks, I agree. It would be really nice if these, if in the reports, you hyperlinked to the comparators because they're hard to, it takes time and effort to find them. And it'd be lovely if you could just hyperlink them so we could go straight there. And
I believe that would be a Shiva matter.
Okay.
So I'm going to punt to someone more
Well
technologically
done.
savvy.
Well done.
But unfortunately,
We'll see
I do
what we
not
can
have
do.
Mendez in front of me, but I can only go by my recollection of it. But I cannot make out that sentence, unfortunately.
Okay, thank you.
Any further questions from the commissioners on item number 10? Any public comment on item number 10? I move to adopt the default motion on item 10.
Second.
Commissioner Adaro,
No.
Commissioner Kasher,
Yes.
Commissioner Hatch, Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, I think the last one is item 36. Yeah. And it's another default, and Commissioner Odero, you can start.
Thank you. So this is the same.
Oh, yeah.
So sorry. This is the same as item 9. 3 failures to file the statement that went from $200 to $9,000. So I would make the same motion as was made by Commissioner Hayward earlier, after, of course, all necessary discussion and public comment.
Yeah, Madam Chair, that was exactly the reason why I wanted to talk about it, is the same theory of penalty that I've expressed ad nauseum already this afternoon.
Okay. Well, my comment to this road we're going down is just that we will be bringing back for the commission's consideration then how to handle these $50 fee referrals. And in fact, if we should handle them at all, I'm inclined at this point to reject the referral from the Secretary of State's office, because it is not feasible for our resources to pursue 4,200 cases to be the collection agency for the Secretary of State. I mean, that's all our role is at this point then. We are not enforcing the act. We are taking action to collect $200 for the Secretary of State, which they could easily have done prior to any referral to us. So I'm just saying this is a problematic road we've gone down. We are now treating people differently, as that has been in effect for 2 years, and many people have paid the additional penalty, pursuant to the Streamline program that was noticed and voted on. So again, to the extent that there's an issue of litigation, I'm confident we would have heard from it by now. But again, we can all have our differences of opinion. I'm just saying this is not a feasible route for the agency or the enforcement division long term. So if this is again the route we're going to be voting on, anticipate in an agenda item in the future after discussions with the Secretary of State's office about our ability to accept referrals. So
Madam
that's
Chair,
my comment.
I'm sorry, I just want to add to that. We were just in discussions with the Secretary of State's office on how to take the referral from 2015 and 2016. So obviously we can add this part to our discussion and coordinate both with the Secretary of State's office and staff here and figure out how we should best move forward.
Okay.
And I would just add to a couple of things. Number one, we've got to deal with this case. And we can deal with what will be brought as an agenda item at the time that it's brought, although it's very nice to have a heads up. But I would only say this about bringing the agenda item and going straight to the Secretary of State and saying we're washing our hands of this. I don't think that's what we're saying at all. I think that, well, I mean, maybe Commissioner Hayward is saying that. My little asterisk is not saying that. I think that I agree that it doesn't make sense for us to go down this road of just collecting the $200 and leaving it at that because of the resources. That doesn't mean that there isn't some other ground somewhere in the gray area where we can do a little bit more and more than just becoming a collection agency and enforcing the act. My only concern, as I stated in number 9, and I'm going to restate as to number 36, is that I think that this is way too punitive, and I think that it doesn't come anywhere near a constitutional amount, and so I think that we need to rethink that. If the number is, instead of 3,000, it goes down to, I don't know, $500, I don't know, just to pick a number, then I think that's the discussion. I don't think it needs to be black and white. As far as, do we collect or do we not collect? Do we now go to the Secretary of State? I just don't think we need to go there right now without further discussion.
Well, that's why I was trying to clarify the last motion, because I do believe Commissioner Hayward said to leave it at 200 because it was her position that legally that is all we could collect. Is that fair?
Yes, that's fair.
So that's why I wanted to give the option.
And if I'm
you're
wrong,
making a motion, you could even lower the proposed fine as an alternative motion, which we're still providing a fine then, and perhaps for this case, and or your position on what the appropriate fine is if you think fines are appropriate. So I just want to make sure we're all voting on the same thing. I feel like my understanding of the prior vote was that the motion was limited to 200 due to legal authority.
And I made clear in my second that with my little asterisk that I wasn't opining on that one way or the other, and that my vote was based on another reason, which was what I think is the constitutionality of the amount of the penalty as part of the enforcement. That's all I'm saying. So yes, maybe we're talking about two different things, and we should hash all that out. But for now, I don't know that it makes a difference. I think Madam Chair's argument would still be, we agreed and we voted on $3,000, and that's what it should be. And anything different than that takes us down the wrong path.
No, I'm sorry. You're saying that's my position? That's not my position.
Okay, I thought you said that the $3,000 was fixed because that's what we
No.
agreed on and voted on. Oh, so could you clarify that?
I'm not sure which statement you're saying. I believe I asked Ms. West how she got to $3,000, and she referred us back to the Streamline program at the maximum being $1,200 that would be collected. And her position was that $3,000 was sufficiently higher for a default case. And then their comment was that we have previously voted and approved defaults on the $50 fee at $3,000 each. That was my position. My position now is just that, if we're voting to never go over the 200, which I guess we don't need to do, but I thought that's what we had done, it's problematic. You can always have rejected that motion and said, alternatively, I would propose reducing this 3,000 per count to X. I'm just making clear that we're all know what our options are.
Oh, understood. I understood the options. The reason I voted the way I voted is because I think it's unconstitutional and it requires more discussion. So however we bring the discussion to the table, we eventually will. We're now facing, and we should, and I look forward to that discussion. Please don't make it next month because I won't be here. But I think we need to, we voted on 9 under a motion. We now need to vote on 36 under a motion. I'll bring a motion to reduce this.
I'm sorry,
go ahead.
Commissioner Hatch wants to speak,
My
before we go.
Sorry about that.
Commissioner Hatch.
You had me there for a while, but I think I'm beginning to slide back over the other direction. Not that it'll matter, but we're kind of like the collection agency for the Secretary of State's office in this case. And collection agencies pile more on top of whatever it is that you never paid in the first place. And the never paid is like $200, right? So then what does a collection agency get for putting it in? Well, if you had a respondent that was cooperating with you, the least you would want is like another $1,000, right?
Actually, the least under the Streamline program, if you do on first contact, is $200.
Oh, $200. Okay. If you cooperate. But so this needs to be higher than that. I just don't think that we can just do, as I know is well intended, but I just think that if these people are ever to get the idea that they're supposed to actually pay them on time, we don't want to encourage them give them an incentive not to. So I would think that we need to at least tack on $1,000 on top of whatever it was they never paid to the Secretary of State. And that would be more than what the Streamline program calls for, correct?
Right. $1,200 is the max amount you would pay in a Streamline program.
Right, but our portion be 1,000.
Yes.
Well, the Streamline, it's 1,000 plus
That's the top, 1,000 plus 200.
Like if you didn't cooperate for months and months, and then you're about to get a default, but they come forward before the default's filed. That's
so
a
if,
thousand.
Yeah,
so
for
if,
instance,
if
if
they
this person-
responded to you,
Right.
But late in the game.
To us, which is
Mhm.
late, it would be what you owe the Secretary of State plus $1,000.
Correct.
That's under Streamline guidelines.
Correct.
So this, where they're ignoring even us, it needs to be higher than that.
That's the theory
Yeah.
of default.
Yeah.
And so the issue is maybe, we'll definitely be readdressing this long term. Maybe we need to
Yeah.
relook at what the Streamline amounts are and then what a maximum would be on a default. And we could discuss that. Again, for this purpose,
I'm thinking it would be a sort of irresponsible not to at least go double what the Streamline amount is when you have a default where they're just ignoring you. Anyway, that's just my opinion.
Commissioner Kasher, anything to add to this discussion before we see if we have a motion?
No, I'll just add, just to clarify the last vote, and I probably should have done this, at the time, but I in hearing the discussion and weighing what was being discussed, I did feel that I felt comfortable bringing the total amount of the fine down, but I wasn't on board with I think we all arrived at that kind of number in a different way. I'm looking at 90, I see different language and I don't mean to bring this back up, but I'm looking at 91,000 in section B, if that's the section that we're referring to. And there's language that references, in addition to other penalties provided by law, a fine of up to or greater than $10,000 or 3 times the amount the person failed to report. Is that the section that we're referring to when we're saying that that we should be limiting the amount?
This Galena West. That's actually the criminal violation section. The one below that, 91,000, sorry, 0.5. I don't know why that number gives me so much trouble. The administrative proceedings section that then refers back to chapter 3 is what I was referring to.
Okay. But the rationale for adopting I guess it's a $200 maximum. What section was that in reliance on?
The annual fee section?
84101.5.
Got it. Okay.
And Commissioner Kasher, could you just try to speak up as much as possible? We're having a little bit of trouble hearing you.
Yeah. Okay. Sorry about that. So my point was that just to clarify, my vote on the last item was really more a statement about the agreement to reduce the fine and not necessarily a definitive statement regarding the rationale or how any of the individual commissioners got to that point.
Okay.
So I just wanted to clarify that.
Okay. So
Commissioner Kasher has his own asterisk.
okay. So this is the discussion on the $50 fee. In this case, in front of us is number 36 with a proposal. What is it even now? I've lost sight of it.
3 counts of 3,000 is what it's proposed at, and then whatever the commission.
Right. So again, just to,
sees.
I know you all know this, but for defaults, we can accept it. We can raise or lower the fine, or we can reject the STIP in its entirety, then hopefully with some direction. So is there a motion on item 36?
All right, I move that we reject it and that the fine be reduced just to be consistent with what we did earlier today.
You're not, so just to clarify, you're not rejecting the default, then you are moving to modify the fine amount.
fair enough, what she said. Okay, I move to accept the default, but modify the amount to $200 per count, just to be consistent with what we did earlier today. And then we can revisit the issue at a time when the general counsel has time to brief us on it.
Is there a second?
I'll second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
No.
Commissioner Hatch,
No.
Commissioner Hayward,
Yes.
Chair Remke.
No.
This motion does not pass.
Is there an alternative motion?
I do. I'll try this.
I sense that.
I would move that we modify this to provide for collection of the Secretary of State's amounts plus $2,000 per
So,
incident.
so 2,200 per count.
Yes, per count.
So for a total of 6,600. That's your motion.
Yes.
I second.
Commissioner Adaro,
No.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
No.
Chair Remke.
Yes.
This motion passes.
Okay. As promised, we will be bringing this issue in a much more broader spectrum back to the commission. And in the meantime, I hate to delay any resolution of cases, but I think it would be wisest to not ask enforcement not to bring us any annual fees until we get a resolution on the scope of what we're addressing.
Trust me.
Wait, I think, okay.
That looks so disappointed.
So that's the consent. The next item is item 40, and this is a recommendation from the executive director to assign the case in the matter of Douglas Hanson to a administrative law judge to hear the evidence and submit a proposed decision and penalty to the commission for our review. If the commissioners agree with the recommendation, no action is required. So do the commissioners have any questions or comments on item 40? Okay, seeing or hearing, oh.
Can I
sorry.
ask one little question?
Yes.
And this is really because I'm a newbie and don't know the answer, of course. There's a place in here where the commission can ask to attend the ALJ hearing.
No, there's the options are to assign it to the ALJ, who will hear the evidence, do a normal administrative proceeding, and then write up all the findings of fact and a proposed decision with a penalty. It gets forwarded to us. The parties can ask for a modification. We can either accept, reject, or offer to hear, review the evidence in its entirety here, including transcripts of the records and the like. So we would be acting more in the role of a review panel at that time.
Good.
Or
Yeah.
a ALJ comes here and we sit in this room and watch that process as they rule on the evidence and the like, but we are hearing and seeing it. Which is an option. I will say we've checked because there are new people. We wanted to make sure no one has ever recalled having had that happen, the option 2, and at least first verified in the last 25 years.
That was my question, is I didn't even know and was not aware of it. And
I would say from my
wondered if it was
experience,
new.
it would be so odd and difficult and not a good use of our time, since we have the full authority to review the proposal that's submitted to us, including reading the entire transcript and reviewing the exhibits if there's any issue.
Duly noted. Thank you.
Any further questions?
That was my question, because I had read that we had that option. How long do one of these take?
This one is estimated to be a 5-day hearing.
5 days over whether there was a material financial effect.
And there's I believe it's a conflicts case and a campaign case.
Wow.
So, okay.
It seemed like a judge should have to order you to do that rather than you volunteer.
I know, I'm like, I'm out.
Okay, so we will, that matter will be assigned to a competent ALJ to propose a recommendation to us, and then it will be brought back to the commission for review. So thank you. Last item are the executive staff reports.
Excuse me, if I could, Madam Chair. Is it in order to reconsider one of the earlier motions? Or does that have to be noticed for a future meeting?
So you're asking to,
One of the earlier.
You can make a motion to reconsider if you were part of the winning side according to Robert's rules. But I don't know if that's the practice here.
we do follow Robert's rules.
I was told we follow Robert's.
Yeah,
rules.
no, we do, I said.
Yeah.
I'm not, this has never occurred, so I'm not sure how.
Well, it's,
So why don't you,
we did more than one of these about collecting for number 9.
Is the other one.
Is the
Right.
other one. So I don't recall how I voted on number 9.
you
I think I
opposed
abstained
it?
on that, did I?
No, oh, did you abstain?
That's right, you did.
It did pass with Commissioner.
Oh, that's
Kinsler.
No.
I voted no. Okay.
So basically, even if we reconsider, yeah. So
All right,
that
I'll let
makes
it go.
sense why it wouldn't matter.
Because you got kind of countermanding orders there. That's all.
Yeah. All right. So our understanding right now is that then you cannot seek reconsideration since we
Nobody
were
else-
in the minority.
Somebody else could, but I can't.
Right. Okay. So on the executive staff reports, I just want to point out what a great job, as always, all of staff does. But as everyone knows, this has been an extremely busy time due to the Form 700 filing deadline. So I'd like to thank all of staff in the SEI unit who receives them and answers questions. Obviously, External Affairs, who is on the front line on the phones answering questions, and the PRCs and legal as well. It is a busy time with lots of work. You can see that in the actual numbers of calls. I don't know, like 1,500 calls in a month. And so thank you, everyone. I mean, that's a lot of work to get 25,000 forms processed and filed in our agency alone. We did implement the e-filing system this year, and once things are resolved and wrapped up a little bit more, we will be doing a presentation on the success of the system and the numbers and who e-filed, who did it, but it's definitely going in the right direction, and we're really excited to have it. But thank you, staff, for all your work on that. Any other questions or comments on the staff report?
I'm just going to comment on the Form 700. I completely agree. I think there's a lot of filings that go on, but on a personal level, I want to thank the staff for having caught my mistake that required an amendment, and the treatment that I received and the help that I received and all the information was amazing. And if everybody else is getting treated the same way, which I imagine they are, I think that's very commendable.
Yeah, I have too wanted to thank the staff for helping me through some troublesome things on my 700. I had no idea it would be so complicated, but we did survive. And I used the new online filing, and it's wonderful compared to filling out pieces of paper.
Yeah.
Thank you.
It's going to be wonderful for us in the long run. Any other questions or comments on the staff reports, or they will be submitted? Okay, thank you. And I will move to adjourn.
Second.
No objection.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
This motion passes.